All right, if you're gearing up for the Australian bar exams, you are in exactly the right place. Today, we're going to demystify a really crucial part of civil procedure, standard discovery in the federal court. So, let's just jump straight in with a big question. Before a case even gets close to a courtroom, where does so much of the time, the money, and let's be honest, the strategic pain get spent? You got it, discovery. It's often called one of the abiding problems of litigation, mainly because of the sheer cost and the mind-boggling complexity involved. And it's this exact problem that forced the evolution of the rules that we're about to break down. Okay, so here's our game plan. We're going to start with the problem itself, then take a look at the old, incredibly broad rule, introduce the modern solution, and then really get into the nuts and bolts of the specific rules you absolutely have to know for your exams. Right, Section 1. Let's talk about this core dilemma. The issue with discovery has always been the immense, and I mean immense, burden it puts on everyone. It's this painstaking, laborious, and frankly eye-wateringly expensive process of sifting through mountains of documents. So, to really get a grip on the new rule, you've got to understand what it replaced. And for that, we have to travel all the way back to 1882, to a case called Company Financier versus Peruvian Guano Co. This single case set the standard for well over a century. And this was the classic test, the train of inquiry. Think of it like you're casting this enormous fishing net out into the ocean. You weren't just looking for a specific fish, you were looking for anything, a piece of seaweed, a current, anything that might lead you to a school of fish. It was just incredibly broad. And look at the language here from Lord Justice Brett. The key words are everything, may, not must, and indirectly. Those two words created a scope for discovery that was almost limitless. You can see how this led to those massive costs and epic legal battles we were just talking about. All right, so that was the problem. Now, let's get to the solution. The Federal Court Rules of 2011 changed the game completely by bringing in Rule 20.14. Now, this wasn't just a minor adjustment. This was a deliberate, fundamental break from that old Peruvian guano test. And this slide just lays it out perfectly. You can see the shift right here. We go from this vague idea of a document relating to any matter to a much sharper, more focused test, directly relevant. As Justice Perham put it, with these new rules, gone are the uncertainties of inquiries. So what does Rule 20.14 actually demand? For your exams, this is mission critical. You need to know that for any document to be discoverable under what we call standard discovery, it has to satisfy three distinct criteria. It's a three-part test, and a document has to take all three of these boxes. That's Rule 20.14, Subrule 1, paragraphs A, B, and C. It has to be directly relevant, it has to be found after a reasonable search, and it has to be within the party's control. And just so we're clear, control simply means you have possession, custody, or power over it. Now we're getting to the absolute heart of the new rule, the real game changer, the test for relevance itself. You see, the rule makers didn't just leave directly relevant as some vague concept for lawyers to argue about for hours. No, they built the definition right into the rule. Okay, pop quiz. For your exam, you need to be able to answer this. What does directly relevant actually mean according to Rule 20.14, Subrule 2? This is a critical point to memorize, so let's break down the definition that's right there in the rule itself. And here they are. Rule 20.14, Subrule 2, gives you four distinct categories. A document is considered directly relevant if it falls into any one of them. So it could be a document you plan to use yourself, one that actually hurts your own case, one that helps your opponent's case, or one that hurts your opponent's case. You need to memorize those four limbs of Rule 20.14, Subrule 2. But hang on, being directly relevant is only the first hurdle. The rule doesn't expect you to boil the ocean to find every single piece of paper. It provides a really crucial practical limit on this whole burden, the reasonable search. This is all laid out in Rule 20.14, Subrule 3. It's basically a common sense check on how far a party needs to go. It's a balancing act, right? You weigh the potential value of a document against the actual cost and effort of digging it up. Okay, here's a classic curly question, the kind that loves to pop up on an exam. Are documents that only go to a witness's credibility, things that suggest they aren't trustworthy but don't touch the actual facts of the case, are those discoverable under the new rules? And the short answer is no. Now, why is that? Well, because they aren't directly relevant to the issues raised by the pleadings. They don't relate to the substantive issues, so they fail that core test that's set out in, you guessed it, Rule 20.14, Subrule 2. All right, one last very practical question. Is that old super broad Peruvian guano test completely dead and buried? Could a court ever order that kind of massive fishing expedition today? Well, the bottom line is it's most unlikely. Standard discovery under Rule 20.14 is now the absolute default. To get something broader, like that old-school Peruvian guano style, you'd have to make a special application for non-standard discovery under a different rule, Rule 20.15. And the courts have called this a radical order. They don't make them lightly. So, if you remember just one thing from all of this, let it be this fundamental shift. We have moved away from a broad, speculative process, that old train of inquiry, to a targeted, efficient one that is focused squarely on the actual issues in dispute, as defined by Rule 20.14, Subrule 2. 20.14. Burn that number into your brain. Rule 20.14. It is the absolute cornerstone of modern discovery in the Federal Court of Australia. You have to know it. And this brings us to a final thought, where the law crashes into modern reality. In an age of terabytes of data, emails, texts, Slack messages, is the reasonable search framework in Rule 20.14, Subrule 3, still enough to strike the right balance? Now that is a big question you'll be grappling with for the rest of your careers. Good luck with the exams.